So welcome to Jumbo IS and welcome to our lecture series called Prelims Powerplay. Now today we are going to start with criminal justice system in this Prelims Powerplay lecture series Polity section. Okay, so we are covering all the important news items from the past 1 year in this Prelims Powerplay series, and currently we are covering Polity, and within Polity currently we are covering criminal justice system. As you all know, we have covered till judiciary. So today let's start with criminal justice system. Now, I won't waste any much more of your time. Okay, so let's straight away jump into the lecture. Let's start with criminal justice system. Okay, now, just a second. Yeah. So in this criminal justice system, which topics we shall cover? So first of all, we'll talk about extradition. Okay, recently a key conspirator of 26/11 Mumbai attacks, Tahavvur Rana, was extradited from USA to India. So what do we mean by this extradition and what sort of laws are there in India with respect to extradition? Okay, we'll talk about this. Then Prime Minister announced that he had repealed a colonial era law which was redundant. Okay, he basically remarked that how can a colonial era law survive 75 years after independence? And that colonial era law was the very draconian Dramatic Performances Act. So what was this law? We'll talk about this. Then we'll talk about a recent Supreme Court judgment with respect to remission of prisoners. So what do we mean by remission? We'll talk about this. And then we'll also talk about another thing with respect to convicts in jails, and that is furloughs and paroles. Okay, so these are the 4 topics that we shall focus all our energies on. So let's start discussing them one by one. Let's start with topic number 1, which is extradition. Okay, now what do we mean by extradition? Look, the thing is that if there is a person who is basically convicted of any crime in India, but he absconded from India, went away from India, ran away from India and is hiding in some other country, and that some other country has basically used its police to catch that person. So India can request that country to extradite that person to India because that person is basically convicted in India. Okay, or that person is wanted for a particular crime in India. Now this process is known as extradition. Okay, so if anyone breaks law in India, okay, and runs away to USA, or if anyone is wanted for any crime in India and runs away to USA, and US authorities catch them, okay, then India can request extradition of that person to India. So US authorities would hand that person to India, and then that person will face justice in India. That was the case with Tahavvur Rana, a key conspirator in 26/11 attacks in Mumbai. Okay, and he was caught by US authorities. Now, India had filed an extradition request to US many years ago. That request was not being processed in USA, but USA recently agreed to extraditing Tahavvur Rana back to India, and he came back to India and now he's facing justice in India. Okay, so what we need to know is what is this extradition? So the basic concept, extradition basically means bringing back a person who is wanted in your country from some other country by requesting to that country back to India. Clear? This is what extradition is. Clear? So let's gather some more details about extradition which can be asked in your prelims examination. Okay, that's our purpose basically. So look, for extradition to happen, well, India needs to have some understanding with that country. For example, there is a person who is caught in Pakistan. Okay, now India and Pakistan don't have that mutual understanding, so Pakistan would never hand over a person wanted in India back to India. Okay, Pakistan already harbors many criminals from India in their country, right? So for extradition to work, there needs to be an understanding between the two countries, right? And that understanding happens through a treaty. So the two countries need to have a treaty in place, okay, agreement in place. And then that person would be extradited based on the provisions of that treaty. Now currently India has extradition treaties with 48 countries. Okay, so if anyone is wanted in India and is found in these 48 countries, well, India can send a extradition request. Okay, and if there is anyone in India wanted in those countries can request an extradition request. Okay, so India has extradition treaties with 48 countries, plus with 12 other countries, India has extradition arrangement on reciprocal basis. So if they'll hand over someone, we'll hand over someone. Okay, but with 48 countries, India has a proper extradition treaty. Now, all these extradition treaties that India has will be based on or would come under the Extradition Act of 1962. Okay, so India created a law way back in 1962, and all these treaties that India negotiates with different countries, well, they are based on this Extradition Act 1962. Now, some of the important provisions of this Extradition Act are as following. It is important for us to know them also. Okay, look, as per this Extradition Treaty or Extradition Act 1962, it is only possible if a treaty exists between India and the requesting country. So, extradition is not possible if there is no treaty. Okay. Now, one condition is there: the offense for which extradition is sought must be a crime in both the requesting and requested countries. Okay. So, if there is a criminal who is charged with a crime in India and is found in USA, but that crime is not considered crime in USA. Okay, let's suppose, for example, drug possession. So, someone is wanted for drug possession in India, but maybe USA does not, or a particular state in USA does not recognize drug possession as a crime. So, India cannot extradite that person. For extradition to happen, that crime for which the person is being accused should be recognized as a crime in both countries. Okay, this is known as dual criminality. So, remember this provision. Okay. The extradited person can only be prosecuted for the offense for which their extradition was requested. So, India will tell USA that we are prosecuting this person for this particular crime. Once that person is handed over to India, India cannot add other crimes also. The person will be only prosecuted for the crime that the requesting country requested. Okay, that is important. Okay. Now, extradition shall not be granted when the person sought has been convicted or acquitted in the requested state for which offense for which extradition is required. Basically, dual criminality only. Okay. Yeah, this is the case. This point that I just underlined. This is the case with India-USA extradition treaty. Okay. So, let's suppose Tahavvur Rana is being prosecuted for terrorism charges. Now, Tahavvur Rana is also being prosecuted for terrorism charges in USA. And USA has given punishment, has found him guilty or acquitted him. If US court has already heard about that, well then India cannot request that person. You understand my point? So, if USA is already hearing case with respect to that crime, then India cannot request that. Clear? That's it. So, that's all you need to know as far as extradition is concerned. Now, quickly let's move forward to second topic. Okay? So, second topic is Dramatic Performances Act. Now, what is Dramatic Performances Act and why we have included this in our discussion? The thing is that Prime Minister Narendra Modi basically made a statement that some colonial era laws survived in India 75 years after independence also, until his government repealed them formally. One such law was the draconian colonial era Dramatic Performances Act, in which the dramatic performances, street plays, street performances, dance, music performances, local music and dance performances were banned by the British government or heavily regulated by the British government or colonial government in India. Okay, so he says that this law still existed even after 75 years of independence. Okay, so what is this curious case of Dramatic Performances Act? Let's talk about this. Okay, so yeah, Dramatic Performances Act. So the thing is that first of all, what is Dramatic Performances Act? So first of all, you need to know that it was enacted by the British colonial government in India to control public dramatic performances, street dance performances, street plays, stage dance performances, all these things that were done by the British government. Now, why did the British government do that? In 19th century, basically they enacted this law in 19th century, 1880 something, okay, 1870s. Now, the purpose was that the British government found that some of these plays were being used, some of these dramatic performances were being used to propagate nationalist propaganda, nationalism, anti-British feelings. So they enacted this law so as to heavily regulate this. Okay. So enacted by British colonial government to control public dramatic performances, particularly those that were considered scandalous, defamatory, seditious, anti-British or obscene. Okay. Now, under this law, the government could issue orders prohibiting performances, notify these orders by the proclamation, and grant warrants to police to enter their stage shows, arrest people, seize materials related to performance. Heavily regulated. Okay, dramatic performances were heavily regulated. Now, this was enacted by the British to clamp down on budding Indian nationalist sentiment following the visit of Prince of Wales Albert Edward to India from October 1875 to 1876. So Prince of England basically visited India till 1876, and they didn't want this prince to visit anti-British feelings in India. So that is why these laws were enacted. But it's not just this act, okay? It's not just this law. There were other laws also to prohibit nationalist propaganda in India. So Vernacular Press Act to regulate Indian language newspapers, okay? Sedition law was enacted, which still survives, by the way. Okay, these laws were enacted. Now, what is the current situation with respect to Dramatic Performances Act? Okay, so as soon as India got independence, in 1956, Allahabad High Court declared this law unconstitutional. Okay, this law was declared unconstitutional, but it still survived. It was not operational. No one can implement it, but it still existed. Okay, until it was formally deleted by Parliament through repealing and amending Second Act. Under this repealing and amending Second Act 2017, many laws, many redundant laws were repealed. Among those redundant laws was one such law, this law, Dramatic Performances Act. Okay. Now, the question might be cropping up in your mind is that if Allahabad High Court declared it unconstitutional, then why was there a need to basically repeal this act? Okay. For that, you need to understand this doctrine called Doctrine of Eclipse. Okay. Eclipse. Just a second. Yeah. Doctrine of Eclipse. Okay. Now, what does this doctrine say? This doctrine says that if there are any colonial era laws, okay, that are found to be violative of Indian constitutional fundamental rights in Indian constitution, then those laws will be declared unconstitutional and they will get eclipsed. Okay. By eclipse, that means that these laws will still exist, but they won't be operational. If in future Government of India amends the constitution, not government, Parliament amends the constitution, and as per the amended constitution, this law is not unconstitutional, then this law will again come to the front. So this law has not died permanently. It has just been hidden till the constitution is amended, and in that amended constitution, this law is valid. Clear? So as per doctrine of eclipse, this law still existed, but it was not operational since 1956. But Government of India decided to formally repeal this law, okay, through repealing and amending Second Act 2017. So remember this act, because this act repealed all the obsolete laws, colonial era laws, okay. One such law was Dramatic Performances Act. And remember this thing, Doctrine of Eclipse. Clear? That would be all. And now let's quickly jump to third topic, which is premature remission of prisoners. Okay. Now, recently, Supreme Court gave a verdict. Okay. Generally, prisoners who are lying in jails, well, their sentence can be remitted. What is remission? What do I mean by the statement that their sentence can get remitted? Well, I'll explain that. Okay. But let me first tell you what Supreme Court said. Now, if any convict or jail inmate wants to remit his sentence, he has to make a formal application. Supreme Court recently said that, well, now they don't have to give any formal application. If the state government feels that this person's sentence has to be remitted, the state government can on its own remit that person's sentence. Okay? No formal application is required, though formal application should be made. Okay? But in case the state feels that this particular person's sentence should be remitted, even if he has not made a formal application, it should be done, it should be allowed. Clear? Now, the pertinent question that crops up in our mind is, what is remission? Okay, so let's talk about this. So, premature remission of prisoners. First question, what is remission? So, what do we mean by remission? reduction of a prison sentence without changing the nature of the sentence. Okay, so let's suppose someone got the punishment of 10 years imprisonment. Okay, but he was let off. He was released from the prison after 7 years. Okay, he did not have to serve 3 more years. He was let off the prison after 7 years. Then we'll say that his sentence of 10 years was remitted by 3 years. Okay, this is what we mean by remission. Generally, remission is granted on factors of good conduct. Okay, when the person was in jail, he showcased good conduct. Maybe he's ill, maybe his family emergency is there. On various multiple reasons, the applicant can submit. Okay, and the jail authorities, the state government can take a call whether to remit the sentence or not. Now, the entire provision of remission of sentence or the entire power of remitting a person's sentence lies with the president, okay, lies with the governor of a state. What is the power? We'll talk about it. And it also lies with the state government. The remission power of president and governor is different, and the remission power of state government is different. Currently, we are talking about remission power of state government, and the recent Supreme Court judgment is also about the remission power of state government. We'll talk about president later and the governor, but currently we are talking about state government. Okay. Now, as per section 473 of Bharatiya Nagrik Suraksha Sanhita or section 432 of CRPC, the earlier CRPC, well, this section grants state governments the power to remit sentences. So the power to remit sentences comes to the state government from this law, BNSS or CRPC. Remission process starts whenever an application is made to the appropriate government, and generally that is state government. So remember this, okay? There are 3 kinds of remissions. One provided by the president, the other can be provided by the governor of the state, and as per BNSS or CRPC, state government. Okay? The power to remit a person's sentence given to the president or the governor is constitutional, whereas the power given to state government to remit a person's sentence is statutory under the law of parliament. Okay? Now, state government can prescribe conditions for granting remissions. They can prescribe conditions, good conduct or many other things. Okay? Now, this is different from the power of president and the governor to remit sentences under Articles 72 and 161. Okay, remember what we are currently talking about, or what the Supreme Court was talking about, it was talking about the remission powers of state government. The remission powers of president and governors are different. Okay, now there is one more thing. State governments can remit a person's sentence, but there is one limitation, and that limitation is provided in BNSS. The limitation is that if a person is given a life sentence, okay, life sentence. If a person is given life sentence for an offense where he could have been given a death sentence. Okay, so the punishment for that offense was death sentence or life imprisonment, and the person was given life imprisonment. Then the state government cannot remit that person's sentence if he has gotten a life sentence before 14 years. So he has to complete 14 years and then only his life imprisonment sentence can be remitted. You understand the point? This is one limitation to the power of state government. Whereas in the case of president and governor, there is no such limitation. They can remit the sentence even before 14 years. Clear? Now, what is the significance of this move by Supreme Court? Let's talk about this. The reason why Supreme Court said that you can remit the sentence of a convict without him or her formally applying for it is that already India's jails are overflowing. Already India's jails are overflowing. As per the data published by National Crime Records Bureau, prisons in India have a 131.4% occupancy rate. That means beyond capacity. In the prisons of India, prisoners are beyond that prison's capacity. Okay, so if you can basically remit the sentence or let go of some prisoners on the basis of good behavior and you feel they are not a threat to the society, then let go of them because our prisons are already overcrowded. Okay, so this decision by the Supreme Court should be seen in this light. Okay, they don't even need to formally apply. State government can remit their sentence suo motu. Clear? Now this topic ends there only, here only. Okay, but what about the power of remitting a sentence that is given to the president, the constitutional power, and the constitutional power of remitting a sentence given to the governor? Okay, so let's talk about both these powers. So the president and governor, mind you, these powers are different because the state government's powers come from CRPC or BNSS. President and governor's power come from the constitution. Okay, there is no limitation to that. Now, Article 72 gives that power to the president. Okay, and apart from remission, there are other powers also. You must be familiar with this. Article 72 of the Indian Constitution grants the president the power to grant pardons, reprieves, respite, remission of punishment. So remission is just one power. The president can grant pardon, reprieve, respite, and to suspend, remit, or commute sentence in certain cases. Okay. Now this power of president lies in following cases. If the person has been imprisoned or given a sentence due to court martial by an army court, okay, if the offense in which the person is being punished is against a law relating to the matter to which the power of union extends, okay, so generally president power extends to violation of central laws. So if there is a criminal under central law, then the power extends. Plus, the power of president extends to death sentence also. So generally, the power of president to basically forgive the prisoner extends to those prisoners who are punished under union law, court-martial people, and people who are given death sentence. Whether under union law or state law, immaterial. If anyone is getting a death sentence, president can pardon that death sentence. Clear? As far as the governor is concerned, governor also has similar powers. Okay, exactly same. Article 161 provides similar powers to the governor of the state, but there is a subtle difference. Okay, one difference is that the power of the governor extends to only those laws where state government has the power. Okay, not central government, state government. Second, governor's powers do not extend to court martial. They do not extend to death sentence. Death sentence, governor cannot pardon a person who's been given a death sentence. Okay, that is the thing. This is the only difference. Now, what do we mean by the terms pardon, reprieve, respite, remission? Okay, they might ask a question on that. So let's take a look at the meaning. Pardon means that the president has forgiven. That person has been forgiven. Okay, so if a person has been found guilty and the president grants him pardon, he won't go to jail and no criminal case would be lodged against him. Okay, he will be free to go as if nothing happened. This is the power of pardon, full forgiveness. It's rarely given. Okay, then reprieve. This involves temporarily postponing the execution of a sentence. Let's suppose there is a person who got life imprisonment. Okay, and his life imprisonment starts now. But the president can give him reprieve, that is a breather of 30 days. That his life sentence will start after 30 days. So he's been given a gap of 30 days basically. Okay. Respite grants a lesser sentence due to special circumstances such as a convict's health. Lesser sentence basically means that let's suppose a person was given 10 years of rigorous imprisonment. That means he would have been in solitary confinement and all. Respite means that he will be given 10 years of normal imprisonment. He will be treated like a normal jail inmate. In case of rigorous, well, he'll be treated a little differently. Okay, he'll have to do a lot of labor in solitary confinement. He'll be put in a different section. That is rigorous. Okay, so the quantum of or the time period of the punishment or the sentencing is not changed. Only the nature of sentence has been changed from rigorous to normal. This is respite. And in case of remission, well, if 10 years of rigorous imprisonment becomes 7 years of rigorous imprisonment, this is remission. The quantum of sentence, the time period of sentence is changed. Okay. Plus, it was also written that the president can suspend the sentence for 30 days, 60 days, remit, remission, commute. Commute means again basically shaving off some years. Instead of 10 years, you're now given 5 years of imprisonment. Okay, the president can do that. These are constitutional powers given to president and governor, whereas in the case of state governments, those were statutory powers. Okay, that would be all as far as this topic is concerned. And now let's quickly jump to topic number 4, which is power to grant furloughs. Okay. Now, the reason why I added this term was, or this news item was, to basically make you familiar with the term furloughs and parole. Okay. So basically, what are these terms? Parole or furloughs? You must have heard about this, that there is a person who is basically in jail for 10 years. But maybe there is a marriage in his family, or maybe his parents are not doing well, they are hospitalized, right? So maybe that is the case, okay? They are hospitalized. So he is given a holiday of sorts for 10 days. He's let off the jail, okay? He has been released from the jail for 10 days. Then he has to come back, okay? This is parole or furlough. So parole or furlough is that a prisoner is sent out of jail for some time. Clear? So both parole and furlough are one and the same thing. Okay, in that regard. But there are a few subtle differences between the two. Okay, so I want you to be familiar with those subtle differences. That is why I've included this news item. So let's understand what is parole, what is furlough. So the basic idea you've gotten, okay, parole and furlough. Let's talk about it, okay. So yeah, the basic idea is that you have been given some days off from the jail, okay. But there is a basic difference between furlough and parole, okay. The thing is that let's suppose you are sentenced for 10 years, okay, and let's suppose you have been given furlough, okay, for 30 days. That means that these 30 days would be counted as your jail time. This would be counted as your jail time. It won't mean that after these 30 days you have to complete 10 years only. You understand? Now, after these 30 days, this person has to spend 9 years, 11 months in prison. Okay, because these 30 days when he was out would be considered part of his jail time. That's the benefit, okay? But when it comes to parole, well, these 30 days won't be counted as your jail time. So after you come back from parole, you will still have to serve full 10 years. You understand? Sentence continues to run despite the release. Sentence is suspended and the quantum of sentence remains intact. Okay? Generally, furlough is granted for long-term imprisonment. But parole is generally granted to those prisoners who are there in jail for short-term. Okay? The reason for giving furlough is that because the person is for long-term. So he gets lonely, he has not seen his family members for a long period of time, and he has behaved well in the jail. Okay? So jail authorities can give him a furlough, okay, so that he can meet his family members and all that. In case of parole, well, the reasons have to be specified. In case of furlough, you don't have to specify any reason. In case of parole, you have to specify a reason. Maybe you're ill, maybe you're a farmer and your crops are being harvested and you're the only laborer in your farm. That can be the reason, okay? Or maybe you're fighting your case in the Supreme Court and you have to go to the Supreme Court to fight your case because it's your date. Then you can be given a parole. Make sense? There are some other differences as well. Furlough is granted by Deputy Inspector General of Prisons. So furlough, for getting furlough, you have to apply to or write a written application to DIG, Deputy Inspector General of Prisons. For parole, Divisional Commissioner gives you parole, okay? Now, the reason for furlough is for breaking the monotony of imprisonment, the person gets ill. For parole, you have to specify a specific reason. Furlough is generally given 1 or 2 times, but parole can be given multiple times. Okay, this is the basic difference, and that would be all. I won't go further. I won't also go into the details of why this was in the news. Okay, because that is not important. You just need to be familiar with these two words and what's the difference between the two. Okay, and I would stop at here. With that, we conclude today's session. Okay, that would be all. And please do not forget to revise this lecture from the notes provided on the Telegram channel. And the practice MCQs that I have promised for economics as well as polity would come very soon, like in 1 or 2 days. So stay tuned for that as well. Okay. On that note, I'll be signing off with the promise of seeing you again with another lecture of Prelims Powerplay. Thank you, everyone.